option, depending on your financial circumstances, to have an attorney appointed for you, or again, depending on your circumstances, you may have to go out and seek one of your own through your own financial means. Now, in addition to discussing whether or not you may obtain an attorney, there are also some other things that we will discuss here this morning. Most importantly, I like to believe is we're going to discuss your bond. And so what's going to happen is I am going to go ahead, I will give you what you've been charged with. I will then ask you, of course, whether or not you believe you'll be able to make bond. And then I'm going to discuss also whether you have special conditions which are attached to your bond. Now, for some of you, ladies and gentlemen, because of the allegations that you will have special conditions. An example of those are, if there are some of you, which I believe there are, you are alleged to have been involved in charges that involve battery, aggravated assault, or simple battery, which means that you are alleged to have been involved in a violent act with someone else. If you are alleged to have gone on a piece of property that you do not belong to, that does not belong to you, or you don't have permission to be on, that also may require that you have a special condition to your bond. And so if I tell you, ladies and gentlemen, based on your allegation, that you are not to have contact with another person, that means you are not to email them, you are not to call them, you are not to text them, you are not to go anywhere that they are, because it could result in you getting additional charges and the revocation of this bond. If I tell you you aren't to go to a place, please do not go to that place unless I tell you that you have the right to go there with the sheriff's office. And then that means please contact the sheriff and they will assist you into going to that place I've told you not to, so that you can get any items that may belong to you there. An example of that would be, again, if I've told you don't go to a particular residence that you may have lived with a friend, family member, girlfriend, boyfriend, I will typically tell you, you do have the right to go there so long as you are accompanied by a deputy from the Clayton County Sheriff's Department. That means you cannot go alone. And again, if you do, you are subjecting yourself to potentially additional charges. Now, I told you that we will talk about your bond. In addition to talking about how much your bond will be, we will also discuss whether or not you'll be able to bond out and how that happens. There are three ways that an individual can make their bond. They can pay it in straight cash, they can go through a bonding company, or you can do what is called a property bond. Cash bond is pretty simple. If I tell you your bond is $6,000 and either you or someone you know has $6,000 that they can bring up to you, up to the sheriff's office, they can use that to bond you out. If you go through a bonding company, bonding companies typically require that you have either 10 or somewhere up to 15% of that money in cash. So again, the example I like to use, if you are alleged to have committed a battery, I tell you your bond is $5,000. A bonding company is probably going to ask that you have anywhere from $500 to $750 in cash to give them that you don't get back in order for them to assist you in bonding out. And then the final way that I mentioned to you, ladies and gentlemen, is what's called a property bond. With a property bond, what happens is either you or someone you know has to have a piece of property that they have a deed to that has 3 times your bond in equity. So again, if you are charged with a battery, I own a home, I want to use my home as my bond, I need to have at least 9,000 times 3, that amount of equity in that property. That person would then take the deed to their property, bring it up to the sheriff's office, and then the sheriff would hold on to it until your case is resolved, okay? Now, one caveat to what I just said about those bonds. If I tell you you are to not have contact with someone as a part of your bond, that person cannot come up and bond you out, because remember, you can't have contact with them. So if you are, again, alleged to have been involved in a battery, aggravated assault, simple battery, simple assault, and I tell you, you can't have contact with your mother, father, brother, sister, girlfriend, husband, wife, that person cannot come to the Clayton County Jail or the sheriff's office and attempt to assist you in bonding out in any way. Now, in addition to those things, so we've discussed your bond, we've discussed how you would make your bond, the different ways that you can make your bond. There are some of you, ladies and gentlemen, at least one person who I have denied bond to. It's either going to be because based on a review of their criminal history, I don't think it's appropriate, based on a review of the facts, or because this individual is either on probation or parole currently. And it's because of that, I will tell you that at this time you don't have bond. Doesn't mean you can't get bond later, but you won't get it today from myself. Now, there are also some of you who are charged with misdemeanor offenses. When you step up to the camera you will have a choice in addition to us talking about your bond. I'm going to talk to you about something called a preliminary hearing. A preliminary hearing, for those of you charged with a misdemeanor, is where you, the defendant, will come into a courtroom, your attorney will be there, the judge will be there, and then the police officer who arrested you. It is their job, it's not your trial, but it is the officer's job to tell the judge all the evidence they have against you that they believe then supports your arrest. If a judge believes they don't have enough evidence, your case can be dismissed. Doesn't mean it can't be brought back later, it just means it'll be dismissed at that time. So if you are charged with a misdemeanor, among the other things we will talk about is whether or not you want to have your preliminary hearing, because you can either have it or you can waive it, and that's up to you. If you choose to have it and you don't make bond, I'm going to give you a court date for your preliminary hearing. You tell me, Judge, I'd rather waive my bond and go ahead and move my case along, then of course you have that right as well. And I will make sure that I allow you to exercise that right and then move your case to the solicitor's office. Some people ask me, well, what's the difference, Judge? Well, if you decide you want your hearing and you don't make your bond, it'll be set in roughly 30 days for those of you charged with misdemeanors. You make your bond, you don't have the hearing. If you tell me, Judge, I don't want the hearing, typically your case is going to move a little faster because it goes from my hands straight to the solicitor's office, where they'll decide if you have enough evidence and they'll then start the prosecution phase. So again, for those of you charged with misdemeanor, I will, in addition to talking about your bond and any special conditions, that'll be something that we will discuss as well. Now, at this time, ladies and gentlemen, what I'd like to do for everyone, if you would, please raise your right hand, and we're going to swear everyone in together. Do you all swear or affirm the testimony that you're about to give here today will be the truth and nothing but the truth? And if you so do, please repeat and say, I do. Okay. And so up first, I'd like to have, just make sure I can hear you. I'd like to have the women, please, of course.
Okay. Adams.
Yes, it should be first up, Ms. Coletta Adams.
And yes, and Judge, we can you, if possible, locate an interpreter? Spanish.
Yes, I think I heard you. So what I'd like to do, Madam Deputy, is just have, is that for Mr. Ovida Amador or Ovida Amador?
Yes, and
Okay.
it's another one. What's the last name, sir?
Your Honor, was that for a Spanish interpreter?
Yes. We only need it for one.
Okay.
Just for legal purposes, I always get even though they speak English, sometimes, you know, just to get it done as well.
Sure. So what I'd like to do, Madam Interpreter, typically is we'll hold them for last. I do see we have two individuals that also are fugitives from justice. So what I'll do is probably do the fugitives first and then do the Spanish male last.
Receive. Thank you, Judge.
All right. Thank you. All right, first up, I have Miss Adams. Are you Miss Coletta Adams? I don't think I can see her, Deputy.
We get off the wall, stand from the podium, hands behind your back.
She's still off camera. Yep, okay, there she is. Are you Miss Adams?
Yes.
Miss Adams, I have you here this morning. You're charged with 1 count of no license and 1 count of distracted driving with a hands-free device. Do you understand that, ma'am? Can you hear me, Miss Adams?
Here goes.
Yes.
Okay, so Ms. Adams, you are going to be released here this morning. So what that means is you were charged with a misdemeanor. And so, you know, the decision has been made to do that at this point. So of course, I just want to make sure you understand you will not have a right to a preliminary hearing. So your hearing is going to be waived at this time. Do you understand?
Yes.
Do you have any questions about anything for me, ma'am?
No.
Okay, so I don't have in front of me your court-appointed form at this time, but my question to you is, were you working at the time, ma'am?
Yes.
And how much were you making per month?
It's 450.
450, okay. So I am gonna go ahead and appoint you a court-appointed lawyer this morning. And so they will get your information, ma'am, and they'll be in touch with you about assisting you on your case, okay?
Okay.
All right, ma'am, well, I don't have any other questions of you. Do you have any questions of me?
No.
All right, ma'am, well, good luck to you, and you should be released later today.
Okay. Thank you.
Thank you. Next up, I have Ms. Latia Mayo, M-A-Y-O. Are you Ms. Mayo?
Yeah.
Ms. Mayo, you are charged with 1 count of battery for a bond of $5,000, 1 count of criminal trespass for $1,500, 1 count of obstruction for $2,000, and 1 count of giving a false name for another $1,500. Your total bond is $10,000, ma'am. Do you believe you'll be able to make bond?
Mm-mm.
Okay.
No.
And let me ask you this, ma'am. I see you have your court-appointed form there. Were you working before your arrest, ma'am?
No, I was supposed to be on my way to a job.
Okay, and so I'm gonna go ahead, since you weren't working, and appoint you a court-appointed lawyer this morning. As far as your preliminary hearing, ma'am, do you want to have your preliminary hearing or do you want to waive it? Okay, so again, remember what I explained to you. You do have a right to it. It's where the officer comes in. The officer's got to provide what evidence he has against you. Or you can waive that hearing and I'll send your case straight to the solicitor, which moves it a little faster. Which would you like to do?
Waive it.
Okay, so you're gonna sign a form there shortly, ma'am, waiving your hearing. Again, your bond is $10,000. The only other thing I want to make sure you understand this morning is you do have special conditions, ma'am. There is an allegation that you were involved in an incident with a Mr. Gregory Nichols. So you are to stay away from Mr. Nichols and to stay away from the address of 111 Indian Lake Drive. Do you understand that?
That's fine.
And if you have any items there, as I mentioned earlier, please contact the sheriff's office if you make bond and they will assist you in going to that address. Good luck to you, ma'am.
You can take it somewhere else. All
Okay.
right, next.
Next up, I have Miss Natasha Simmons. Are you Miss Simmons? Ms. Simmons, you are charged with 5 counts of violation of possession of Schedule Controlled Substances Act, Schedule 1. Each bond amount is $7,500. You are charged with 1 count of possession of a weapon during the commission of a crime for $8,000 in bond. And you're also charged with loitering or prowling for $1,000 in bond. Your total bond, ma'am, is $52,000, ma'am. Do you believe you'll be able to make bond?
No, sir.
Okay.
But I have a question.
I'm sorry?
I have a question. So
Yes,
I have a bond for all of them?
Yes, ma'am. You do have a bond for each of those charges. So each of the BGCSAs is $7,500 apiece. The possession of weapon is $8,000, and the loitering and prowling is $1,000. Does that answer your question?
Yes, sir. Thank you.
Okay, and I understand you said you don't believe you'll be able to make bond.
No, sir.
How much are you making per month, ma'am? If
I'm
you
not
have,
working. I'm not working right now.
so I'm going to go ahead and appoint you a court-appointed lawyer this morning as well. Now, you do have a special condition as well, and that is to stay away from the place that this was alleged to have happened at 2185 Mount Zion Parkway. Do you understand that?
Yes, sir.
All right, ma'am. Do you have
Thank
any
you.
questions of me?
No, thank you so much.
No problem, ma'am. And you enjoy the rest of your day and good luck to you. All right. Oh, actually, I'm sorry, Deputy, if you could bring her up just one more time. I'm sorry, I forgot to tell her one last.
Yes, I was gonna ask Your Honor what.
Now, ma'am, I do want to let you know, because you are charged with a felony, you do have a couple of upcoming court dates I want to make you aware of. One, you're going to have a preliminary hearing. That's going to be on the 28th of this month of August. And you're also going to have a bond hearing where they'll review your bond as well on September 1st. Do you understand that?
I understand. So so if I make bond, I can still bond out.
Yes, I mean, if you make the current bond that I have, you do have the ability to bond out. But if for some reason you don't, you do have a scheduled bond hearing that's going to happen on September 1st and a scheduled preliminary hearing. Again, if you don't make bond, that's going to be August 28th of this month.
Bond hearing for to reduce the bond?
Yes, ma'am, they can
Oh.
consider and reduce it if they so choose.
Okay.
All right, any other questions?
So I don't have to sign nothing for a preliminary hearing? It's
No,
automatic.
no, ma'am. No, ma'am, because you're charged with felonies, because she's charged with a felony deputy, she automatically gets the preliminary hearing.
Received.
Okay.
All right, you're good.
All
What's
right,
that
thank
date?
you.
What's the date she need?
8/28 for the preliminary and 9/1 for her bond hearing day. Okay, and next up should be Miss Lorraine Smoot. Are you Miss Smoot?
Yes, sir.
Ms. Smoot, you're charged with 1 count of theft by receipt of stolen property as a felony. And then you also are charged with 1 count of driving with a suspended license. The theft by receipt of stolen property carries a bond amount of $4,000 and a suspended license, a bond amount of $1,500 for a total bond of $5,500, ma'am. Do you understand that?
Yes, sir.
Do you believe you'll be able to make bond, ma'am?
Hey, what exactly is bond again?
Get
It's
up.
$5,500.
You can write it down on it, babe. Write it down. The ink pen right there. Write the bond amount.
Oh, he taking all the
15%.
other go straight down like he's supposed to do. That's how they supposed to do it, just like that.
Are you currently working, ma'am?
I'm in training, sir.
Okay. So you just started the job?
Yes, sir.
All right, so I'm gonna go ahead based on that and appoint you a court-appointed lawyer. Since you just started working, I'm gonna put that you likely wouldn't be able to make the bond as well. So you are charged with misdemeanors here this morning. And so you have a right to the preliminary hearing or not. As I explained earlier, the preliminary hearing is where, oh, excuse me, I apologize. One of these is a felony. The theft by receipt is a felony. And so you actually do automatically get a preliminary hearing if you don't make bond. So your preliminary hearing is going to be August 28th at 8:30 a.m. via Zoom. And then your bond hearing, where they can review your bond, is going to be September 1st. Again, 8:28 for preliminary hearing. Bond is going to be September 1st. Okay, and total bond is $5,500. All right, any questions of me, Ms. Smoot?
No, thank you.
All right, ma'am, good luck to you.
Thank you.
All right, next up should be Yaisha Watts.
Yes.
Are you Ms. Watts?
Yes.
Ms. Watts, you're charged with 1 count of simple battery family violence. Your bond amount is $2,500. Do you believe you'll be able to make bond, ma'am?
Yes.
Are you currently working?
I have no idea.
Okay, so I am going to appoint you a court-appointed lawyer. Earlier, I spoke about a preliminary hearing. Because you're charged with a misdemeanor, you have a right to have the hearing or not. Do you want to have it or waive it?
I would like to have it.
Okay, I'm sorry, I couldn't hear you. So you will go ahead. I'm going to write down your hearing date, and that's going to be August
No, I want to
29th.
waive it. I want to waive it.
Okay, I'm sorry. I thought you said half. So, okay, I'm going to go ahead and waive it. So then we'll waive your hearing. I put that down. I'm appointing you a court-appointed lawyer. Your bond is $2,500. Only other thing I want to make sure that you know, ma'am, you do have special conditions on your bond, and that's to stay away from the alleged victim, Mr. Quincy Tomlin, and also the address of 4766 Channing Drive. Do you understand that?
Yes.
So, ma'am, if that was your residence, like I said before, if you make and when you make your bond, please contact the sheriff's office and they will assist you in going out to that address and making sure that you get any items that you may own there until your case is resolved or that bond is modified, okay? All right, ma'am. Well, since you're waiving your bond, you probably got a document there you'll have to sign, and once you sign that, you're good to go. Good luck to you.
All right, you can go with them.
All right. All right, with the gentleman, first up, I'm showing Mr. Justin McCray Connolly.
Finally.
Are you Mr. Connolly?
Yes, sir.
All right, Mr. Connolly, you're charged with 1 count of criminal trespass for a bond in the amount of $3,000, 1 count of burglary for a bond in the amount of $50,000, and 1 count of possession of a firearm during the commission of a crime for a bond of $8,000. Your total bond is $61,000. Do you understand that? Is that a yes?
So,
Oh, okay. Do you believe you'll be able to make that bond, sir?
no,
Are you currently working?
so,
All right, sir. So I am going to appoint you a court-appointed lawyer this morning. Now, because you're charged with a felony, sir, you got 2 important court dates I need to make you aware of. One, you got a preliminary hearing on August 28th at 8:30, and then you've got a bond hearing that's going to be set for September 1st. Do you understand that?
yes, sir.
Only other thing I want to let you know is if in fact, at some point you do make bond, you are to stay away from the address of 1014 New Hope Drive. So that would be the church where this was alleged to have happened, okay?
Yes, sir.
All right, do you have any questions of me, Mr. Conley?
So,
Is that a no, sir?
yes, sir. No.
All right. Well, sir, that's all I have for you. Good luck to you.
Take him back.
Next up should be Zion Gilliard, Gilliard.
That's a fugitive.
That's a fugitive, sir. He filled it out anyway, but no, he's a fugitive. He's gonna be last.
Is that the one with the children charges is a fugitive?
It's 2 people. That's a
Yeah,
fugitive.
I had 2 fugitives as a Carranza Guillermo and a Steven Snyder. This person I'm talking about is Zion, Zion Caleb.
Yes, Gillard, Zion Caleb Gillard is a fugitive.
Okay, so he must have additional warrants then, because I'm showing he's got one.
Snyder. No, the fugitive is Gillamore. Gillamore.
Yeah, that's a different person. That's a different.
Gillard, come on.
Yeah.
No, he's not.
Yeah, Are you Mr. Zion Gilliard?
Yes. So the interpreter is
Okay.
Yeah, he told us he was a fugitive.
Sir, how do you spell your last name?
EILLIARD.
And how do you spell your first name?
EION.
Okay, yes, this is him, deputy.
Okay.
All right, Mr. Gilliard, you are charged with 5 counts of sexual exploitation of children. I have denied you bond this morning, sir. After reviewing all of the allegations here, that is a decision within my discretion that I have made. You are, however, going to have a couple of court dates I need to make you aware of. The first is going to be on August 28th. Pay attention, Mr. Gilliard. Your first court date is going to be August 28th of this year at 8:30 a.m. That's where you're going to have your preliminary hearing. Do you understand that?
Yes, sir.
Your second court date is going to be September 1st, where they can review your bond and determine if they want to give you a bond at that point. Do you understand that?
Yes, sir.
Now, are you currently working, sir, or were you working before you were arrested?
I was working before.
Okay. How much were you making per month?
Per month?
Yes, sir.
I know hourly I was making $14.75.
Okay, so 14 an hour, and were you working about 40 hours?
Yes, sir.
Okay, so
So
you're
more than that, I was getting paid bi-weekly,
okay. How much per biweekly?
$14.75.
Oh, well, no. How much biweekly on that check? Like on your check that you take home?
My take home was like 1,070, something like that,
Okay, and is that every week or every other week?
every other week.
Okay, so based on that, sir, I am gonna go ahead and appoint you a court-appointed lawyer this morning. Do you understand that?
Yes, sir.
So again, sir, just so that you are aware, you have been denied bond this morning. The 2 dates that we just spoke of, your first is going to be your preliminary hearing on 8/28. Your second is going to be your bond hearing. That's gonna happen on 9/1. Do you understand that?
Yes, sir.
Any questions about anything, sir?
That'll be all.
All right, sir. Well, that's all I have for you. Good luck to you. All right. Next up should be, I have Mr. Edwin Layton Earns, E-R-N-E-S.
Layton,
Have one in route as a B and B and one in route.
Are you Mr. Layton?
Yes.
All right, give me 1 second here, Mr. Layton. All right, so Mr. Layton, you are charged with 1 count of terroristic threat as a felony, and then also 1 count of conspiracy to commit a felony. Do you understand that?
No, not really. I don't understand.
Okay, so here, we can't get into, I'm not gonna get into too much of what's going on, but I can tell you, based on my review of the warrant, the allegations are that you were involved in a verbal altercation with another individual. You made a threat to kill him. And then later on that same day, the allegation is that you had someone come and assault him. And so with the evidence that the officer currently has, he's alleging again that you made that verbal threat and that you had someone assault this individual. And so at this point, your bond for the terroristic threat is $5,000. Your bond for the conspiracy to commit crime is $50,000 for a total bond of $55,000. Do you understand that?
No, I don't. I didn't know anything about any of this. And
Remember what I said earlier, sir. You don't want to get into the facts of your case. So you want to tell me what you knew and didn't know. I'm not the one to have that discussion with. That'll be a little later on with your lawyer and with your preliminary hearing, the judge that'll be presiding over that. I'm just here to let you know what the allegations are and what your bond currently is. Okay. I understand you may have some frustration, but that's for a later date to speak with your attorney about. Do you understand?
yes,
Now, let me tell you this. If you make your bond at some point on this case, whether it's today, tomorrow, or in a few weeks, you got some special conditions. I don't know if you did this or not, but I'm just telling you, in the meantime, you are to stay away from these people, Taheem Johnson and Tonal Canty, okay? Do you understand, Mr.
Okay.
Okay, you're also to stay away from the address of 681 Flint River Road where this is alleged to have happened. So again, I'm not here to pass judgment. I don't know if you did it or not, but I'm just making sure you understand. Taheem Johnson, Tanal Canty are individuals you stay away from, and you stay away from the address of 681 Flint River Road. You've got a court date of 8/28 this month, your preliminary hearing if you don't make bond, and then also your bond hearing on 9/1. Now, how much were you working before this incident, sir?
I was supposed to start work yesterday. I didn't know anything about any of this. Like I got a child out here.
Yes,
I'm with
sir.
her.
Yes, sir.
I'm
So
with her. I got a child.
prior to you starting this new job, were you working?
No,
Okay, so based on that information, sir, I did go ahead and I am going to appoint you a court-appointed lawyer to help you with your case, okay? Now, again, I understand the frustration, but right now, I just need to make sure you understand your charges, the things you are and people to stay away from. Do you have any questions about those things that I told you, sir? Not about your case. We can't talk about that, but do you have any questions about anything else?
so how much is the bond?
55,000.
15 papers for.
All right. Any other questions?
Is that 10%?
15%.
So 10%, if it were 10% with the bonding company, on 55, you're talking about 5,500, maybe a little more.
It's 15%. 10%.
All right, sir? All right, good luck to you. Next up, I have Mr. Nicoy Lewis.
Louis,
Are you Mr. Lewis?
Yes, ma'am.
Mr. Lewis, you're charged with one count of obstruction of an officer. I have given you a bond in the amount of $2,000. Are you currently working, sir?
Awesome.
All right, so I am going to appoint you a court-appointed lawyer this morning. Do you believe you'll be able to make a $2,000 bond?
Because I'm not working and I just moved from New York to Chicago.
Yes, sir. I understand. So I am going to just record that you don't believe you'll make the bond. I've assigned you a court-appointed lawyer. Your bond is $2,000. The last question I have for you is this. I spoke earlier about a preliminary hearing. Because you're charged with a misdemeanor, you have a right to have that hearing or to waive that hearing. Which would you prefer, sir?
I prefer to go ahead with it, sir.
All right, to go ahead and do what?
With the trial.
Okay, this is not your trial right now. This is just a hearing date for the judge to review the evidence. You have the right to have it. It'll be later this month, or we can waive it and that'll move your case along faster and it'll go straight to the prosecutor. Which would you prefer?
No, I'll wait for the date, sir.
Okay, so I'm gonna record here that you are waiving your right to that preliminary hearing. So there's gonna be a document that the deputy is gonna hand you for your signature, and then that's all I have for you, okay?
Could you repeat, sir? I'm not waiving I wanna wait for the hearing that you.
Oh, I'm sorry, I apologize.
Yeah.
I thought you said waive. Okay, so let me put that down then. My apologies, sir. So you do want the hearing. So the hearing is going to be for your preliminary hearing. It's going to be the end of this month. It's going to be August 29th at 8:30 a.m. And that's going to be just like we are today via Zoom. Okay?
write your court date down.
So
Oh,
do
you
you
said
understand?
August 28th,
August 29th.
29th.
Yep, 8:30 a.m. via Zoom. And your bond, Mr. Lewis, is $2,000. All right, any questions, sir?
No, sir.
All right, sir, good luck to you.
Thank you.
Next up, I have Mr. Rico Mosley. Rico Mosley.
Y'all been sitting back in there?
Sir. You got one person?
Yeah, I know.
Are you Mr. Mosley?
Yes, sir.
All right, Mr. Mosley, you are charged with one count of simple battery, one count of obstruction of an officer as a felony, one count of criminal trespass, and one count of aggravated assault. I've reviewed your case, sir. I am going to dismiss the count of aggravated assault. However, you have a bond of $1,500 on the trespass, a bond of $10,000 on the obstruction, and a bond of $5,000 on simple battery. So your total bond, sir, is going to be $16,500. Again, that's $16,500 for your bond. Do you understand that?
16,016,000.
Yes, sir, I understand. Yes, sir.
Okay, are you currently working?
I'm not at the moment. I have apartment going. I was homeless.
Okay, so I'm
Yes.
gonna record here that you're not gonna probably be able to make that bond. I'm also gonna appoint you a court-appointed lawyer. Do you understand that?
Yeah, appreciate that.
Now, you are alleged to have committed a felony, so you have a right to a preliminary hearing. Your preliminary hearing is going to be August 28th at 8:30 a.m. via Zoom. Okay, August 28th, 8:30 a.m. Yes, sir. And then you're also going to have a bond hearing that's going to be September 1st at that same time, 8:30 a.m. via Zoom.
That's your bond.
8:28 preliminary hearing, 9/1 bond hearing. All right, sir. Unless you have any questions for me, that's all I have for you. So good luck to you.
All right, take on.
Appreciate it.
Yes, sir. Next up, I have Mr. William Demetrius Welch.
Well.
All right, are you Mr. Welch?
Yes, ma'am.
Mr. Welch, you're charged with one count of simple assault, family violence, one count of simple
I'm sorry.
battery.
I'm sorry.
You're fine. One count of simple assault, one count of simple battery, each carries a bond of $3,500 for a total bond of $7,000. You have special conditions, sir. That is to stay away from the alleged victims in this matter, Kennedy Welch and a Jocelyn, I believe it's Pellins, Poelintz. Okay, do you understand that?
Yes, sir. You
Now,
said
sir,
3,500, sir?
$3,500 apiece for a
Yes,
total
sir.
bond of $7,000.
Yes, sir.
Okay, now again, you are to stay away from these individuals while this is pending. Now, from what I can tell, it looks to be that you may, and you don't have to answer this, but it looks to be that you may have some relation to these people. And so you may have been living with them, but let me advise you, I have also put into place a stay away from that address where this occurred. So if that's where you were living and you do make bond, please contact the sheriff's office until your bond is modified so you can go to that place to get any personal items that you need. Do you understand that?
Yes, sir, I do.
All right, now were you working before this incident, sir?
I was in between jobs at the time. But,
All right, when was the last time you worked?
about a month and a half ago, sir.
Okay, so I'm gonna go ahead, sir, and appoint you a court-appointed lawyer this morning. Your bond was $7,500. Do you believe you'd be able to make that bond?
Yes, sir.
Okay. And then lastly, you're charged with 2 misdemeanors, so you have the right to either have your preliminary hearing that I spoke about earlier or to waive it. Would you like to have it or waive it, sir?
Waiving it for the letter date, just having it a letter date.
Say that one more time.
Could you expound on the difference?
So the difference between the two, if you can you hear me?
Asking about the waiver, he's
Yeah,
now.
the connection stopped for a second. So Mr. Welch, here's where we are. The preliminary hearing is the opportunity for the police officer to come in and he tells the judge what happened and tells the judge what evidence he has. If the judge says, okay, I agree, there's enough evidence, then your case goes to solicitor and they'll charge you.
Yes,
If the judge disagrees, he'll dismiss your case. Doesn't
Yes,
mean they can't bring it back later, just means they're gonna dismiss it for the time being, okay?
Yes, sir. Yes, sir.
Now, if you say to me, Judge, I really don't want to have that hearing, what I'm going to do is bypass that hearing, send you straight to the solicitor, let them determine if they believe they've got enough evidence, and then they'll decide whether your case is going to go forward or not. So again, you can either have the hearing or you don't have to, and you can do what is called a waiver. Which would you like to do, sir?
I would like to have the hearing.
All right.
Bond right now.
Say that one more time.
It doesn't affect my bond right now, right?
It does not. It's not.
Okay.
But let me remind you, if you do make bond, you automatically, again, remember, you waive that hearing if you make bond, okay?
Oh, okay.
So your court date, sir, is going to be, because you're charged with misdemeanors, it's going to be August 29th of this year at 8:30 a.m. And that's going to be via Zoom. Again, that's going to be August 29th of 2023 at 8:30 a.m. via Zoom. Your total bond is $7,000. And of course, you have the stay away against those two women involved at 5726 Rex Mill Drive. Do you understand that?
Yes, sir. I have one question for you, Your Honor.
Yes, sir.
Is this gonna be at the Clayton County Courthouse?
Any future court dates? Yes, sir. Any future court dates you have will be right here in this courthouse. And if you do make bond, sir, you'll get at your last known address, all of the notices. And so you do have the right, let's say you say, hey, I make bond, I can't go back to that address. The thing I would tell you to do is to make sure that you give them another address here at the sheriff's office so that when you get future court dates, it's sent to a different address that you know you have access to.
Okay, yes, sir.
Okay?
All right, thank you, Judge.
All right, thank you. All right, next up, I have Kareem Williams. Ms. Daisy, we're almost to these gentlemen, or I can skip them if you need me to, if you are somewhere else.
Yeah, good, Your Honor. Thank you.
Ms. Day, which was it? Did you need me to move ahead or?
We should be okay, Judge.
Okay, all right, let me know if that changes. I think I've only got one more anyhow.
Thank you.
Are you Mr. Williams, Kareem Williams?
Yes.
Mr. Williams, you're charged with 1 count of false report of a crime, 1 count of false statements as a felony, 1 count of hit and run causing an accident, and following too closely. Your false report of a crime carries a bond of $5,000. The false statement, $3,000. Following too closely is and causing an accident, $10,000, and leaving the scene, a bond of $3,000. So your total bond, sir, is $21,000. Do you understand that? Do you understand that, sir?
Yes.
Okay. Do you believe you'll be able to make that bond?
Thanks. Yes.
Okay. Were you currently working before this, sir?
I was.
How much are you making per month?
Per month. Probably 2,600.
Okay. So do you know if you still have that job if you make your bond?
I'm not too sure.
Okay.
I still have that job.
Do you have any children?
No, sir.
All right. So based on that, sir, I am. I'm going to go ahead and appoint you a lawyer this morning. And so they will be in touch with you to discuss your case with you, okay?
Okay.
So again, 21,000. Let me also tell you, you've got a court-appointed attorney and your upcoming court dates. Your next court date, if you don't make your bond, is going to be your preliminary hearing on 8/28 of this month at 8:30 a.m. via Zoom. That's going to be the next court date. And then you also will have a bond hearing, which will be September 1st of this year. All right, do you understand that?
Yes.
Do you have any questions for me about anything, sir? All right, if you don't have any questions, good luck to you. Give me one moment, sir. Are you Mr. DeMarco Yarrell?
Yes, sir.
All right, Mr. Yarrell, you're charged with 1 count of obstruction of an officer as a misdemeanor and 1 count of giving false name. The obstruction carries a bond of $2,000. The false name carries a bond of $1,500 for a total bond of $3,500, sir. Do you believe you'll be able to make your bond?
Yes.
Are you currently working?
No.
So I'm going to appoint you a court-appointed lawyer. Now, you have the right to your preliminary hearing or you can waive it. Which would you prefer to do? I'm sorry?
You can do it one.
I can't hear you, sir.
No. He thought you was asking about appointing an attorney.
Oh, I've appointed you attorney, sir, but remember I talked about a hearing where the judge is going to review your evidence later this month, or I can send your case straight to the solicitor. Which would you prefer? One is a little faster than the other. One allows the court to review your evidence.
You do it? You do that?
Oh, review, okay. So I'll go ahead and set that hearing date for you. Now, because you are charged with misdemeanors, that means your hearing date is going to be August 29th at 8:30 a.m. And that's going to be via Zoom here in the jail. Do you understand that?
Yeah.
All right, sir. If you don't have any questions for me, that's all I have. Good luck to you. All right, so let's
Spanish
definitely,
interpreter,
yes, let's do Amador Ovida first.
Amador Avida.
Amador.
Amador,
See the
the young one. No, he's not.
And then what we can do, Deputy, since Mr. Guillermo needs an interpreter, we'll just do the fugitives one by one.
Yes, sir.
All right. All right. Ms. Dea, can you hear me?
Yes, sir.
Okay, if you would, please raise your right hand. Do you swear or affirm that the translation that you will provide from Spanish to English will be appropriately transcribed and will be the truth and nothing but the truth to help you God?
I do.
All right. So Ms. Day, if you would go ahead and just introduce yourself. This is Mr. again, Amador Oviedo, Oviedo.
Señor Oviedo, mi nombre es Deyanira Bermúdez. Yo voy a ser su intérprete en la mañana de hoy.
Okay. Now, Mr. Oviedo, my name is Judge Thorpe, and I'm going to discuss with you the charges that have been brought against you.
Señor Oviedo, yo soy el juez Thorpe y yo voy a hablar con usted de los cargos que le han sido imputados.
Okay. You have been charged with 1 count of theft by shoplifting,
A usted se le acusa de un cargo de ratería de tiendas
1 count of false statements.
y un cargo de dar declaraciones falsas.
Now, I have reviewed your case and you will be released from here today.
Yo he revisado su caso y usted va a ser puesto en libertad en el día de hoy.
But please remember, do not go back to the place where this is alleged to have happened at 6550 Highway 42.
Pero recuerde, no regrese al lugar donde se presume o presuntamente ocurrió el incidente, que fue en la 6550 en la carretera 42.
Okay. Now, the last question I have for you, Mr. Amador, were you working before you were arrested?
No.
La última pregunta que tengo para usted, señor Amador, es, ¿estaba usted empleado antes de ser arrestado?
Got a question for you. He's speaking. What? Do you speak English? No. I signed it to him because he's still Spanish. Like that.
¿Estaba usted trabajando antes de ser arrestado?
No.
No.
Okay. So I am going to go ahead and appoint you a court-appointed lawyer, sir. So once you leave, that lawyer will be in contact with you about your case.
Yo le voy a nombrar un abogado para que le represente, señor, y tan pronto usted salga, este abogado se va a poner en contacto con usted.
Okay.
All right.
Okay.
Do you have any questions of me, sir?
¿Tiene usted alguna pregunta para mí, señor?
Sí, tenía una pregunta.
Yes, I have a question.
Okay. Yes, sir.
Sí, señor.
Cuando le estaba diciendo de que cuando dijo response, le quería preguntar por qué le dije eso a la policía.
The interpreter cannot fully understand what Mr. Oviedo is saying. Actually, the interpreter cannot really hear what Mr. Oviedo is saying.
He's gonna speak English.
Okay. Since we've started actually in Spanish, we can't really, the preference would not to be go back and forth. Can you put him a little closer to the podium and see if that helps the interpreter?
Come on, speak up.
Hable más claro, señor.
Quería hablarle de cuando le dije que tenía 17 años.
I would like to talk about when I said that I was 17 years old.
Okay. At this point today, sir, we cannot discuss your case. I'm just here to discuss your bond and make sure that you are released today.
Señor, en estos momentos no estamos acá para hablar de su caso. Yo solamente estoy acá para hablar de su fianza y para decirle que usted lo van a poner en libertad.
Okay.
Okay?
¿Cómo a qué horas?
Like around what time?
That will be up to the jail.
Eso va a depender de la cárcel.
Okay, está bien.
Okay, that's fine.
All right. Good luck to you, sir.
Buena suerte, señor.
Gracias.
Thank you.
Next up to me, Mr. Guillermo. And Deputy, while he's coming up, I looked at that email. So you sent photos of it. Is the standard?
No, it's not standard because you're not receiving our emails. He just was trying to get them to you so you could see them. See proof that they signed it. It was just proof that they did sign their stuff.
Okay. So do you think at a later time they'll be able to just scan them?
Yeah, I'm gonna try to scan them to you again because I already scanned them twice. So I'm
Okay.
gonna go to another department and scan them.
Okay, and if there is an issue, let me know. I'll email you a different address if it's something to do with the
Yes,
address.
yes, please do that. Put it in the first appearance email, please.
Okay. So what I'll do as soon as we end, I'm gonna give you a second email address, and you can just send them to both, and we'll see what happens.
Okay, you can put it in the chat. Thank you.
Okay. All right. Good afternoon, sir. Are you Mr. Guillermo?
Yes,
Buenas tardes, señor. ¿Es usted el señor Guillermo?
yes, Your Honor.
Okay. So, Mr. Guillermo, my name is Judge Thorpe, and I'm here to discuss with you why you have been arrested.
Señor Guillermo, mi nombre es Michael Thorpe y yo estoy acá para hablar con usted de por qué usted fue arrestado.
Muy bien.
Now, my records
Very well.
show here, sir, that you have an outstanding warrant out of the state of Nevada.
Señor, mis récords muestran que usted tiene una orden de arresto pendiente en el estado de Nevada.
Okay. Now, because of that outstanding arrest, you were picked up by Clayton County to hold you until Nevada decides if they want to come get you or not.
Porque usted tiene ese arresto pendiente, el condado de Clayton lo detuvo hasta que se decida si el estado de Nevada lo va a venir a buscar o no.
Okay. Now, while that decision is being made, Mr. Guillermo, you have the right to a hearing.
Mientras se toma esta decisión, señor Guillermo, usted tiene el derecho de tener una audiencia.
Now, that hearing is not about whether or not you are guilty or innocent.
Esa audiencia no es para determinar si usted es culpable o inocente.
That hearing is about whether or not the procedure that has been taken by the police officers in Nevada and the police officers in Clayton was done correctly.
Esa audiencia va a ser para determinar si el procedimiento que se usó en el Departamento de Policía de Nevada y en el Departamento de Policía de Clayton es correcto.
Now, if you choose to have that hearing can be set for you anytime in the next 60 to 90 days.
Si usted decide tener esa audiencia podría ocurrir en los próximos de 60 a 90 días.
Now, if you say, Judge, I don't want to have that hearing, please send me back to Nevada, typically that can be accomplished in 30 days.
Y si usted le dice usted me dice, señor juez, yo no quiero tener esa audiencia, solamente envíeme de regreso a Nevada, esto puede ocurrir dentro de los próximos 30 días.
So, Mr. Guillermo, my question to you is, would you like to have the hearing and contest the way that this has been done by the police, or would you like us to prepare to send you back to Nevada in the next 30 days?
O sea que mi pregunta para usted, señor Guillermo, es, ¿usted quiere tener la audiencia y desafiar de la forma como la policía ha manejado el procedimiento, o usted quiere ser regresado a Nevada dentro de los próximos 30 días?
Lo que no entiendo muy bien es las dos opciones que me están dando, porque no me dicen el cargo de que se me está imputando.
The thing is that I don't understand, what I don't understand very well about the two choices that I have is because you're not giving me the charge. You're not telling me what I've been charged with.
So according to the information I have, Mr. Guillermo, it looks like you have an outstanding charge in Nevada for what is called larceny. Or theft, just say theft will be it.
Señor Guillermo, por la información que tengo, a usted se le imputa en el cargo en el estado de Nevada de hurto, o sea, de robo.
Okay. So again, you have the right to have this hearing to make sure that the Nevada police and Clayton County police did their job correctly, and that can happen in 60 to 90 days. Or we can start the process of sending you back to Nevada in the next 30. How would you like to proceed?
O sea, una vez más, usted tiene la opción de tener la audiencia para determinar si el Departamento de Policía de Nevada y el Departamento de Policía de Clayton ejecutaron su trabajo de manera correcta, o usted me puede pedir que yo lo envíe de regreso a Nevada en los próximos 30 días.
Si decido la primera, tendría que esperar acá y conseguir un abogado.
If I go with the first choice, do I have to wait here and get an attorney?
Yes, sir.
Sí, señor.
¿Un attorney de Nevada o de acá?
An attorney from Nevada or an attorney from here?
So if you make the first choice, it will be an attorney from Georgia, and it would, again, remember, not to contest your charges. It would just be to contest the procedure that was used to arrest you.
Sería un abogado de aquí de Georgia. Y recuerde que eso no sería para desafiar los cargos que usted tiene pendiente en Nevada. Sería solamente para desafiar o para determinar si el procedimiento se ha hecho de manera correcta.
Oh, ok, y en realidad, mire, sin conocer mucho, yo voy a aceptar la primera de desafiar que me ha tratado adecuadamente acá creo que estamos hablando de, ¿cuál es el estado donde estoy en este momento?
Without a full understanding, I'm going to pick the first choice.
Okay. So again, then let me advise you, we'll go ahead and we're going to put that you would like to have your extradition hearing. And so again, you will get that hearing in the next 60 to 90 days. And in that time frame, you'll be here in the Clayton County Jail until that date is set, okay?
O sea que déjeme decirle que la opción que usted eligió es de aceptar el proceso de extradición y eso se va a hacer dentro de los próximos 60 a 90 días y durante ese tiempo usted permanecería acá en la cárcel de Clayton.
No, pero, o sea, había elegido la primera en donde vemos el trato que se me ha dado acá en el estado y luego ver la de Las Vegas. Esa había elegido.
I chose the first choice to see if I was treated correctly here in the state, and then we go to Vegas.
Okay, so there is some confusion. And I want to clarify.
O sea que usted tiene alguna confusión y yo quiero aclarar eso.
Okay. Now, if you want to make sure that you are treated appropriately here in Georgia, that means you'll have to sit here for your hearing date, which will be anywhere from the next 60 to 90 days.
O sea que si usted quiere determinar o que se determine si a usted lo trataron de manera correcta aquí en Georgia, esto usted lo que significa que usted tendría que quedarse acá detenido por los próximos de 60 a 90 días.
Okay.
Acabo de entender que son 60 a 90. Yo pensé que eran 6. Pero esta.
I just understood the 60 to 90. I thought it was 6.
No, sir. 60 to 90
no,
days.
No, I prefer to do my case in Las Vegas.
There you go.
Okay. Can you ask him that, Ms. Day, in Spanish so I can confirm?
¿Podría usted confirmar eso en español, lo que usted acaba de decir?
Sí, pero que me trasladen a Las Vegas para ver mi caso.
I prefer to be transported to Vegas.
Okay. So what's going to happen then, Mr. Guillermo, is there's going to be some documents that they're going to have you sign saying you're waiving your right to a hearing that will be sent to me, okay?
Okay.
Al señor Guillermo, lo que va a ocurrir es que ellos le van a entregar unos documentos, los cuales usted tiene que firmar, diciendo que usted está renunciando a esa audiencia y ellos me van a enviar esos documentos a mí de regreso.
All right, Mr. Guillermo, do you have any questions for me?
Señor Guillermo, ¿tiene usted alguna pregunta para mí?
Creo que no tengo más preguntas.
I don't think so. I don't think I have any more questions.
Okay, sir. So after you sign those documents, good luck to you and thank you.
Ms.
Okay, señor,
Bermudez.
después que firme los documentos, buena suerte.
Ms. Bermudez,
Yes, ma'am.
can you let him know that he has to sign every document?
Señor Guillermo, asegúrese de firmar cada uno de los documentos que le entreguen.
And he's going to keep one for himself.
Y usted se queda con una de las copias.
Garcia.
Ms. Day, if you just want to give us a few moments while he's doing that, just make sure he doesn't have any additional questions.
Yes, sir. Yes.
Okay. Are you Mr. Steven Snyder?
Yes, sir.
Mr. Snyder, as I explained to the gentleman just in front of you, you're here not because you committed a crime here in Clayton County or in the state of Georgia, but you're here because you have an outstanding warrant in the state of Ohio. Looks to be that you had a failure to appear that is outstanding. Do you understand that?
Yes, sir.
Now, because of that, sir, you have two options. Option number one is you say to me, Judge, I want to go back to the state of Ohio and deal with my charges. If you say that you want to do that, we will attempt to get that accomplished in the next 30 days and get you back to Ohio so that you can get an attorney and deal with those charges if they want to get you back. Or option number two is you say, Judge, I don't know that I want to go back right now. And instead, I want to have a hearing where I can make sure that the Clayton County Police and that the Ohio police did their job correctly. Now, if you tell me you want to have that hearing, that is going to take a little longer, and that usually takes about 60 to 90 days before you have that hearing. Okay? So again, option number one, within 30 days, we'll try to get you back to Ohio to deal with your case if they want you. If they don't, you'll be released. Or in 60 to 90 days, you'll have that hearing here in Clayton County, not on your case, but whether or not the procedure was done correctly. Which would you prefer, sir?
The first option.
All right, and so that would be for you to be sent back to Ohio, is that correct?
Yes, sir.
All right, so any questions for me, sir?
Well, I was wondering why, because I never had a court date out of Ohio. That's why I want to go back to figure out.
Okay, then I can't comment on that, of course. All I have is what has been provided to me, that you have a warrant for your arrest. Now, what's going to happen is the deputy there is going to have some documents for you to sign. There's going to be about 6 or 7 of them. You're going to keep one. The other 5 or 6 are going to be to me. Once you sign those, sir, you'll be good to go, okay?
All right, sir.
All right, any questions for me, sir?
No, sir.
All right, good luck to you, sir.
You sign this. All right, Judge, don't forget to send that email in the chat so that I can have it.
Deputy, I sent it to you. Do you see it?
No, I'm not gonna show it while he's standing here.
Oh, sure, of course.
And Your Honor, I need to speak with you once you come off live.
Okay.
Where'd he come from? You know how to get me in?
He's going back.
I can call you.
Who's that guy right there?
He signed every last one of them. He's headed back there and take.
What about?
All right, and Mr. Guillermo is good to go?
Yes, he's good to go.
Where'd he go?
All right, Ms. Stanley, I'll call you.
Your Honor.
Okay. Thank you, Ms. Daya.
You're very welcome, Judge. It's good seeing you.
All right.